Imagine a scenario. The government pushes through a hypothetical Internal Security Act 2025. It completely bypasses the House of Lords, and its provisions silently overwrite the core protections of the Human Rights Act 1998. The immediate question this creates is not whether this is politically acceptable, but whether Parliament actually possesses the unfettered legal power to execute it, and if the courts are legally obligated to apply it. For over a century, the answer was a resolute yes. This absolute starting point for UK constitutional law was established by the theorist A.V. Dicey, resting on three structural pillars. First, Parliament has the right to make or unmake any law whatever. There are no subject matter limitations on what it can legislate. Second, no Parliament can be bound by a predecessor, and it cannot bind a successor. Finally, no person or body is recognized by the law as having a right to override or set aside an act of Parliament. The courts must enforce the statute. Dicey's formulation was treated as absolute law, but modern legal pressures, from European integration, devolution, and aggressive common law interpretation, have fractured these pillars. The orthodox sovereignty Dicey described is now an illusion. To understand how the model broke, we first have to see how it works in its pure form. The mechanism that enforces Dicey's second axiom, preventing older parliaments from restricting newer ones, is the doctrine of implied repeal. If a later act contradicts an earlier act but fails to explicitly revoke it, the later act automatically prevails. The definitive application of this rule came in the 1934 case of Ellen Street Estates. The core issue was simple. The claimant wanted to use favorable compensation rules from the Acquisition of Land Act 1919. The problem was that the government had passed the Housing Acts of 1925 and 1930, which contained entirely contradictory compensation rules. The court ruled that the legislature cannot bind itself regarding the form of subsequent legislation. The 1919 Act could not immunize itself from future changes, even if it contained language trying to do exactly that. The later Housing Acts successfully impliedly repealed the 1919 Act to the extent of their inconsistency. When dealing with ordinary legislation, Dicey's orthodox model works perfectly. That absolute rule held until the modern era. The first major crack in the Diceyan model arrived in the 2002 case of Thorburn versus Sunderland City Council, famously known as the Metric Martyrs. Did the 1985 Weights and Measures Act implicitly repealed the 1972 European Communities Act? Lord Justice Laws established a new hierarchy. He ruled the 1972 Act was a constitutional statute, meaning it is immune to implied repeal and requires express words. This is a frequent trap in constitutional exams. Do not state that the Human Rights Act or the Scotland Act are permanently immune from repeal. Parliament can still repeal any constitutional statute, but requiring explicit, express language to do so acts as a massive political and legal hurdle. The next systemic shock was external. The UK's membership in the European Union required it to recognize the supremacy of EU law over domestic legislation. To achieve this, Parliament enacted Section 2(4) of the European Communities Act 1972. This served as a legislative instruction, requiring UK courts to read domestic legislation subject to the provisions of EU law. This instruction was tested in the Factor-Tame litigation. The UK Parliament passed the Merchant Shipping Act 1988, preventing Spanish fishermen from registering their boats as British. This directly conflicted with established EU rights. The House of Lords took a step previously considered impossible. They granted an injunction, effectively suspending the operation of the 1988 UK Act of Parliament. This creates an immediate paradox. Suspending an Act of Parliament appears to directly destroy Dicey's third axiom, that no court can set aside primary legislation. The judicial reasoning resolved this by looking at Parliament's own commands. The court suspended the 1988 Act only because the 1972 Parliament voluntarily limited its sovereignty, explicitly instructing courts to prioritize EU law. Parliament ultimately reclaimed this sovereignty decades later by passing the European Union Withdrawal Act 2018. Factor-Tame proves a critical nuance. Parliament's sovereignty includes the paradoxical power to voluntarily limit its own supremacy through the enactment of constitutional statutes. The system also faces an internal threat through the manner and form debate. This questions whether an earlier parliament can dictate the specific procedure a later parliament must follow. The Parliament Acts of 1911 and 1949 serve as the prime procedural example. They created a bypass, allowing the House of Commons to enact laws without the consent of the House of Lords. The validity of this bypass was challenged in Jackson v. Attorney General. The claimants argued the Hunting Act 2004 was invalid because it was passed using the 1949 Act, which itself had bypassed the Lords via the 1911 Act. The Lords upheld the Hunting Act as a matter of statutory interpretation, respecting the Enrolled Act rule. But the real value of Jackson lies in its obiter dicta. Lord Bingham maintained the orthodox view, stating the Crown and Parliament remains unconstrained. Conversely, Lord Stein asserted that parliamentary sovereignty is merely a construct of the common law, created by the judges. Lord Stein used this reasoning to issue an ultimate warning. If Parliament aggressively abolished fundamental rights, like the power of judicial review, the courts might refuse to apply the act. Jackson leaves a loaded weapon on the constitutional table, a clear judicial threat that the rule of law may eventually trump absolute parliamentary sovereignty. Let's return to the problem question. The hypothetical Internal Security Act 2025, bypassing the Lords and implicitly repealing the Human Rights Act. Based on the model we've built, the implicit repeal of the HRA fails. Because it is a constitutional statute under the Thoburn principle, it requires express words to be altered. Procedurally, because the Act bypassed the House of Lords, its validity hinges strictly on perfect compliance with the Parliament Acts. Finally, if the Act attempts to abolish fundamental access to the courts, it triggers the exact constitutional crisis Lord Stein warned of in Jackson. Parliament is still the supreme lawmaking body of the United Kingdom, but the absolute, unchecked power described by A.V. Dicey has been permanently entangled in a web of judicial pragmatism. High marks are never awarded for treating sovereignty as a settled binary rule. The strongest legal analysis comes from tracing the ongoing tension between orthodox Diceian theory and modern common law resistance.